Okay. My clock says 1:35 on the dot. My name is Brianna Allen, and I am from the Cleveland Rape Crisis Center, and I am here to introduce our lead presenter, Camille. Camille joined OAESV in December of 2015 to develop OAESV's legal service program and increase publicized policy engagement. Camille worked with the state and federal lawmakers to shape survivor-centered funding streams, statutes, and administrative rules. She provides training and technical assistance on a variety of civil rights issues with a specific emphasis on Title IX and educational remedies. Camille graduated from the University of Wisconsin Law School. Before joining OAESV full time, Camille was a Rape Crisis Center in OAESV Public Policy and Law Fellow. She also had a civil she also had civil firm experience with Title IX workshop discrimination cases and interned with Wisconsin Coalition Against Sexual Violence, the Wisconsin Department of Justice, and the United States District Court of the Western District of Wisconsin. She is a Teacher for America alum, DC 2008, and holds an MED and a BA.
It wouldn't be right for me to start without being on mute and trying to talk at the same time. So thank you so much, Brianna. It's great to see you. It's great to see everybody. Just so you all know, I am actually coming from a room in the state of Wisconsin right now. You heard Brianna talk a lot about Wisconsin. That is where I am personally broadcasting from today. And the rest of our team is broadcasting from Ohio. So welcome to our panel. We are really excited to talk about this topic that intersects so much with prevention and also is so important for advocates across the board. So for those of you who are joining us and are unfamiliar with Title IX, Title IX is not just about sports. You've probably heard about Title IX in connection to volleyball, softball, track, swimming, any type of sport that since the 1970s schools are required to provide equal access to. But what's talked about less is that this law also is requiring institutions that receive public funding, education institutions, to provide an environment for learning that's free of gender-based discrimination, which includes sexual violence and sexual harassment. So I am joined today with our wonderful panel. OAESV has been very fortunate the past several years to have funding for a legal clinic and also a separate funding for direct legal advocacy for survivors of sexual violence. So within that, we have our wonderful staff today. Kandra Roberts is our LAV attorney. Kandra is a graduate of the Ohio State University, Moritz College of Law, and has a background in public defense and very intense cases involving capital penalties and appealing those decisions. Kandra has been with us for 3 years and has specialized in Title IX practice, representing survivors in K-12 and campus proceedings. She also focuses on civil protection orders, certain employment matters, and she will talk a lot about how Title IX has changed over the past few years. April Carter works with our clinic as well in the capacity of paralegal / general manager of all important things. And April has several degrees from Miami University of Ohio, has a background in technology, which brings a lot of important privacy protections for our practice because there are so many ways that technology and communications interact with just students' experiences on a day-to-day basis. And then Becca Getson is also with us today. Becca also is a graduate of Miami University and the University of Toledo Law School. And she has been working as an advocate for over, 20 years now? I think it's about 20 years in one capacity or another, and has served as a deputy Title IX coordinator at Miami University. So we have a wide range of 12 years. I'm sorry, those numbers feel so different, 12 and 20. 12 years, my apologies. And so we have a broad range of experience and expertise. And what we're going to be talking about today really is how Title IX has changed very acutely in the past 6 years, and each change being very, very foundational to our practice and what we do. There was a big change in 2011 that came into fruition in 2014. Then there were some major changes in 2018 that were solidified in 2020. And now we're looking at some big changes coming up again. And so just for a little bit of background, the Department of Education issued regulations for Title IX in the 1970s. Let me very quickly clarify, there was no Department of Education until 1982. So when I say Department of Education, I mean Huey, which was Housing, Education, and Workforce. They developed the Department of Education in the 80s. Then that department started producing the regulations for Title IX. So the rules have been relatively consistent. They started under Richard Nixon. They did not change until Bill Clinton. Then they changed a very, very small amount under George W. Bush. And the only change was to make sure we were complying with 2 new Supreme Court decisions that came out in the late 90s. They found that they were largely compliant. So, I mean, just a couple of tiny shifts. And then under President Obama, there were massive changes that did not go through the typical regulatory process, that were considered to be very survivor-centered, victim-focused, but very drastically different than what had been in place before in terms of process. And then in 2017 rather, the Trump administration rescinded the Obama guidance. They put federal regulations in the notice and comment process, so they created proposed regulations. After they created proposed regulations, there was about a year and a half of them reviewing the over 100,000 public comment submissions, largely against the proposed changes. The proposed changes went into, we were notified of them. They were released in May of 2020, which was not optimal timing for anyone. And then they were to be effective in August of 2020, also not optimal timing for anyone. So we've seen a lot of drastic changes kind of come into play. And we are here today to talk about some of those changes and what that looks like. I just want to note, and we'll talk a bit more about this at the end of the panel, that Biden's vice presidential office was very heavily involved in the Obama era rules that were released in 2011. And for that reason, we are anticipating a very abrupt shift back to what those rules looked like just a couple of years ago, because essentially the Trump administration vacated what Biden had done as vice president, and now Biden is president. So it's very logical that those things will go back into play because he believes those are best practice. So with that, I have said a lot of things. And I want to start with what is perhaps the biggest question that we have gotten as a clinic. So OAESV provides training and technical assistance in addition to direct survivor services. And we have found that this provision that has changed that I'm about to talk about has been the most consistent source of confusion and stress for both survivors and advocates that are not attorneys across the board. So I will start with Kandra, who, as I said, represents survivors in the Title IX process. So cross-examination has become a necessary part of an institution's process in Title IX, meaning cross-examination is now required. It was not required before, unless you lived in Tennessee, Michigan, I believe Indiana, or Ohio, in which case you are in the circuit, the Sixth Circuit, and there was a court decision that said that cross-examination was mandatory. However, this rule changed and went even further and said that it had to be the advisor of choice that did cross-examination. So how do you, as an attorney, Kandra, prepare for that process in general, and how do you prepare a survivor for cross-examination?
So, as an attorney in a Title IX case, first and foremost, the goal is to have already established an attorney relationship with that client well ahead of the hearing and well ahead of the stage of preparing for the hearing. And so the advice for advocates would be, if you get in contact with the survivor around, well before they even report to the school or around that time, it's really important to try to encourage them to seek legal assistance, explain to them, why that may be important, at least to consult with an attorney. In Ohio, you can always apply for our services at OAESV or at our clinic. And the reason for that is the sooner that we're on the case, the sooner we can do things like prepare for cross-examination. Many survivors that I get aren't actually aware that there's going to be cross-examination. They're not really aware, A, that there's going to be a hearing, or B, if there is going to be a hearing, what that's going to look like. It's become more of a quasi-legal proceeding in recent times, and so they may well not be expecting that, especially if they've been through other kind of disciplinary things or whatever it may be at the school, because those are going to be a lot less formal. But anyway, how I would prepare for or prepare a survivor. First and foremost, when they hear cross-examination, they're going to be worried that it's going to be like the badgering on SVU. And typically a respondent is going to have an attorney advisor. An advisor under the rules doesn't have to be an attorney, but we really encourage a survivor to have an attorney advisor, because not only a cross-examination, attorneys are the only professionals, actually trained in cross-examination, and because typically the respondent is going to have an attorney advisor as their advisor. And, there's really kind of an imbalance if the survivor doesn't have an attorney as their advisor and the respondent does. So anyway, they're going to know that the respondent has an attorney advisor, and they're going to be afraid of answering questions by an attorney. They're not going to expect it, and they're going to expect the worst. And a lot of the worst that they expect is that they're going to try to trip them up. They're going to accuse them of lying. They're going to be confrontational. In reality, genuinely, even with the worst of the worst respondent attorneys that we see, cross-examination in a Title IX hearing is not going to be as bad as the survivor expects. So at the outset, I try to tell them that and try to ease some of that anxiety. So as an advocate, I would, encourage advocates to do that too. I would explain to the survivor the type of questions that may be asked. I do not give specific questions and prepare, I don't give a list of questions I think will be asked, because I don't know. It really depends on what information comes out during the hearing beforehand, what kind of questions the panel may have already asked, or, so I don't want to give specific questions that may be asked, because then they will practice those, right? They'll come up with answers, and then if those aren't the ones asked in the hearing, it's, it makes them uneasy. So what I will typically do is just give a list of topics I think that will be covered. As far as practicing with them ahead of time, I really don't encourage that, because again, it's going to bring up specific questions, and then they've practiced something that may not come up. What I would, with the caveat to that, is I will practice with them if there are specific topics that are really uncomfortable for them to talk about out loud, or really concerning. If there have been inconsistencies in their statements, and they think they're in their previous statements, and they think they're going to have to explain those things, then I will kind of go through that with them and, get them comfortable in explaining those things. And then one of the central critical pieces of advice I give them, and this is true when I was doing criminal work too, this is, and I was representing criminal defendants, this is the advice we always gave them, which is critical. When you're in cross-examination, oftentimes the questions from a respondent's attorney are going to be yes or no questions, because they want to use the information you give them to spin their own way, right? So they will ask open-ended questions. Why did you do this? What happened when? But a lot of their questions are going to be yes or no. And they're going to ask those questions in a way that the survivor is going to feel like they should offer more information, right? So an example may be, you went voluntarily over to the respondent's apartment on that Saturday night, didn't you? And so the survivor's initial reaction may be to say, I did, yes, and then to say, but I did that because I thought, we were going to be in a group setting, or, whatever explanation they want to offer. And really the advice I give is, don't explain yourself. If it's a yes or no question and you can answer with a yes or no, that's what you do. You're going to have a chance to explain yourself in something like a closing statement or your own testimony. And that's a better place to do that than giving the attorney a window open to argue whatever you say. So it can be uncomfortable. You can feel like you have to explain yourself, but for the most part, that's what I really try to explain to them. And then finally, it is up to the hearing officer to determine whether each question is relevant. And so the hearings are kind of wonky now. So with cross, between each question asked to anyone, there's a pause. And the hearing officer says, you can answer that, or you can't answer that, and here's why. They make a relevancy determination for every question. Most questions are going to find relevant. If you as the survivor feel uncomfortable asking or feel it's not relevant, it's okay to ask the hearing officer, or to kind of give a hearing officer a little reason why you think it's not relevant, kind of advocate for yourself. If you, as a survivor, feel like you've already answered the same question over and over, and the hearing officer isn't picking up on that for whatever reason, you can say, I've already answered that several times. Can we move on to another question? It can be really uncomfortable to do that as a survivor, because typically those kind of objections would be done by an attorney, but in a hearing, your attorney advisor can't speak for you. So I would kind of practice with them doing that. You may have to speak up. And then finally, last warning I give is that throughout a hearing, oftentimes a survivor asks for a break when they're uncomfortable and need to, catch their breath. Typically, they're not going to be allowed to do that during a questioning session. And so just kind of explaining that to them ahead of time and getting them in the right headspace is all that you can really do.
Thank you so much, Kandra. And I hear an echo, so I will try to make this as quick as I can. So with that, you've talked about a process that is very clearly rooted in legal expertise and legal judgment, which means that it is inherently tied to the practice of law. And I'm going to pivot over to Becca, who I did mention in the introductions does have a JD. However, Becca made what, in my opinion, is the most wonderful judgment call and determined that she would not take the bar and work in an advocacy capacity using the knowledge gained attaining that JD, but not practicing law. So excellent judgment, Becca. I'm very jealous of your judgment call forever. But without an attorney, so we've used this term advisor and advocate quite a bit. If you were to look at the regulations for Title IX that are in place now, that were in place in 2011, that were in place before that, they make reference to advisor of choice. And the advisor of choice does not have to be an attorney. That can be any person of your choosing. So if you are a non-attorney advisor, or you're an advocate who is not in the place of a non-attorney advisor, but is supporting the survivor in other avenues, how do you prepare a survivor for cross-examination, and who does that cross-examination?
I even wrote this question at the time. I was like, I'm going to have to answer this question. What have I done to myself? So good afternoon, everyone. So as Camille mentioned, so I'm kind of providing more of an advocate perspective on things. And I kind of glanced through the participant list as Kandra was talking. I know that some of you have a lot of experience in Title IX just from having worked with you before. And I don't know if others of you don't. So I'm going to kind of go from the basis of So some of this might be refreshers, or some of it might be entirely new. So bear with me, those folks that have done the Title IX pieces. So for me as an advocate, we want to make sure and focus on the survivor, right? That's going to be first and foremost, is what the survivor needs, what they're looking for. And keeping that in mind, as advocates, we're not trained to do cross-examination. This is not something we're trained to do. It's not something that we have legal expertise in. Even with my background, I do not feel comfortable doing that because I don't practice law, right? So really keeping in mind that what our role as an advocate is and should be. So we consider it actually not best practice to have a advocate be an advisor. So the term advisor itself means you're advising someone on something, right? Which is something that advocates can't really do, right? We can provide information, we can provide resources, we talk a lot about options and what that means. But the second we start talking about giving advice to someone, applying a set of facts to the rules, the regulations, and what gets tricky in the Title IX setting is that technically this hearing is not in a courtroom. It's not a legal setting, right? Because it's usually with administrators, right? This could be just a history professor, and I don't say just, I love history professors. This could be someone who has no idea about what sexual violence is other than the training they've experienced for Title IX. So that gets really hard when we're kind of thinking through how to best prepare a survivor for this process, because oftentimes too, we also want to make sure that they have the best information, and advocates may know the answer to your question, right? May know the answer to a survivor's question. But we want to be very careful about that unauthorized practice of law, and that we're not giving a survivor information or advice that we're not prepared to give, right? So some of the things that I do is kind of think about it in two different ways in terms of cross-examination. The cross-examination that is being given, right? So the ones that the perpetrator, the questions that the perpetrator is receiving and that their advisor or their advisor of choice might be giving, but also being the receiver of cross-examination, right? Having to answer those questions, what that feels like, what that looks like. So I kind of think about it in those kind of two different ways. So if they are preparing questions to ask, ideally, right, in this ideal, wonderful world, admitting the fact that there is still sexual violence, going beyond that, that's the ideal world, right, that they would have an advisor who is an attorney. So that Kandra has already done that work, right, or whoever that attorney is on the case has done that work and prepared them for that cross-examination piece on both sides. Otherwise, who that advisor is, right? So if they don't have an attorney advisor, who is their advisor, right? So as I mentioned, it's not best practice to have an advocate in that role because of the dichotomy of that, and because the role that an advocate should be playing. But what does that mean, and who is that advisor? Now, what gets tricky about who the advisor is that some advisors have a lot of training and are attorneys. Other advisors don't have that. So being aware of who those advisors are, what that looks like, to make sure that that survivor is prepared for what they're about to walk into, both giving and receiving questions, right? I also, when I talk with survivors about preparing for cross-examination, the questions that they receive, making sure that they're aware that they might be asked questions that are going to be triggering, that they are going to be difficult to answer, that they might have to address those different things. And some of that they're going to be prepared for. Other things they may not be prepared for. So something like sexual history that is not typically allowed to be asked about. During cross, they might still be asked about it. So to make sure that they're aware that those questions might be asked, even if the panel who's that's doing the hearing don't allow that question to be answered, right? They might still be asked about it, and to kind of be prepared for those difficult questions and to have those emotions and triggering. Some other things I do is kind of very similar to court advocacy, right? Is where can you kind of breathe and slow down, right? That once you're asked a question, you don't have to answer it immediately. You can take that pause, take that breath to kind of determine what your answer is going to be, right? I would also think through as well, and we focus a little bit more on higher education institutions, like that tends to be where our brain goes, but also through K through 12 is if you have a minor that you're working with as well, right? What is the age of the survivor and what at what point their like emotional and cognitive developmental skills are in terms of answering questions, right? In most part, K through 12 is not going to receive cross-examination, and Kandra can speak a little bit more to this as well. But being just aware of that, right? What the age of the survivor is and where their brain might be in terms of being triggered, what information they are going to be intaking at the time. Can they take notes up with them, right? So when they're answering questions, can they have notes about what they want to, how they might want to respond? Just kind of being aware of all those kind of different things and what those triggers might be. I also encourage people to ask for breaks. Typically in these kind of hearings, they're going to be a lot more open to taking that break, that breather in between. If they get asked a really triggering question, especially as an advocate, you might see it, right? You might say, oh, that's like they're gone, right? Like they have stopped thinking about what's happening in this room right now. And to kind of encourage them to ask for a break, take a sip of water, whatever it kind of is to kind of help ground them a little bit. So hopefully that helps a little bit answering in terms of that cross-examination piece and kind of how to help prepare a survivor, both once again, kind of giving and receiving is kind of how I think about it as well.
Follow up just briefly. I know I've already talked to you all about cross-examination a lot, but you brought a few things to my mind. You were just talking about breaks, and earlier I had said typically they're not going to give a break during a session. So, you know, they'll make the survivor finish answering the questions of whatever questions the respondent's attorney or advisor has before taking a break. But the caveat to that is, and this is true for any part of a hearing, but also during cross-examination, if the survivor has a question for their attorney advisor, or you know, just needs to talk to them if they think the questions are getting irrelevant for some reason, or that they shouldn't have to answer it or whatever, they can ask for a break to do that. And the hearing officers are supposed to, and usually do, be pretty lenient about giving, you know, a 2 or 5 minute break to talk to their attorney. However, many schools will not allow that to happen mid-question. So once the question has been asked, they're typically going to want the who's ever responding to answer it before asking for that break. So in other words, they're not going to allow who's ever answering to take a break to talk to their attorney to, you know, come up with an answer to that question or avoid that appearance. But you can still ask for a break, talk to your attorney during cross. And I think it's best practice to cover that with the school ahead of time. If nothing else, to bring to their attention that and remind them that the survivor, I mean, both parties have that right. And so you will get a hearing prep meeting with the hearing officer or the administration just before the hearing, and you have a chance to ask questions about the hearing procedures. And that's one I will bring up. Hey, during cross, you know, I know my client has a right to ask me questions and advise them. I know I can't speak up myself during the hearing, but you know, I know they have that right. How would you like that to happen? And so that's already been covered. And then a couple other things. What I didn't mention, you're correct, Becca, in that there's preparation for 2 different types of cross-examination. There's preparation for responding to questions from a respondent's attorney advisor, which is typically the most concerning to a survivor, but also we have to prepare them for asking questions of the witnesses or the respondent. The questions are going to be asked during the hearing by the attorney advisor, typically. The questions, so the survivor may oftentimes will come to me as the attorney, you know, before the hearing with a list of questions they want asked of each party, either of the respondent or witnesses or both. Or mid-hearing, they'll be jotting down furiously questions they want asked. And like Becca said, our role is different An advocate always is going to try to advocate in the survivor's best interest. As an attorney, that's true. However, the core of our job as an attorney is to strategize and work in the systems we have, right, to get to the end result that the survivor wants, whatever remedy it is, whatever result it is. We have to strategize in order to do that. And sometimes that means that we're not going to do the things, we can't do the things the survivor necessarily wants. You know, they may not understand the parameters and it can be frustrating for them. Oftentimes they just want answers from the respondent about specific things, and sometimes that's a means of their healing process. But we have to be careful to continue to only ask the strategic questions. And so, you know, just preparing the survivor ahead of time. You're welcome to have input on the questions, obviously, both ahead of time and during the hearing. However, I'm not going to ask all the questions you propose, probably. I'm not going to, or there may be questions I ask that, you know, we haven't discussed. And the reason for that, and explain the reason for that being, again, as an attorney, you're going to be able to strategize more about not wanting to give the respondent too much space to talk more, right? And so I usually say less is more. I don't ask a ton of questions unless there's things I need that respondent to admit to, or whatever it may be, because I don't want them to have any more of a voice typically. And really same with witnesses. I don't want to conflate issues. And so if the witness has already testified that some pretty, or given statements that are pretty, they give enough information to either help or not hurt our case, I'm not going to give them an opportunity to say, oh, you know what, maybe I misremembered that, and, you know, or over-explain themselves and get things, again, confused. So those are warnings to give the survivor. And then finally, I mentioned earlier that most respondents are going to have an attorney as their advisor now. I don't think I've had a hearing since the changes came in. Frankly, I don't think I've ever had a hearing in post-secondary where it wasn't an attorney for the respondent, maybe once. So, you know, they're typically going to try to get that attorney. If it is a non-attorney and it is just an advisor, and it is someone, you know, particularly inexperienced, that is going to be even more alert and aware during the hearing, because the questions that come from that person, again, not trained in cross-examination, and so they may actually be more confusing, difficult to understand what's really being asked. They may be more offensive. So while an attorney can't interrupt in real time and object to a question or explain something to their client, you can write notes during the cross session. And so I might write notes to say, hey, I suggest objecting, say, or asking, formally objecting, but hey, say to the hearing officer, I don't feel comfortable answering this, and here's why. I think this is why it's not relevant. Most hearing officers are going to be also aware and calling those things out, but not always. Sometimes we have to guide the hearing officers into the right direction so that they're following the rules they're supposed to. Finally, so again, I said that as an attorney, you can ask those questions, or you can help, guide the survivor during questioning. There are schools that try to say you can't pass notes during a question, or that the survivor can't look at the notes an attorney gives them before responding to a question, which is not true. And so again, that's another thing I will try to address that misconception before the hearing begins, and like that hearing meeting, and say, again, my client has a right to an advisor, and that includes during cross. So just to be clear, my practice of doing that, I will be writing notes if it's in person, or if it is virtual, which all of them have been and continue to be thus far since the pandemic began. And I think we're going to continue to see that. So typically like on a Zoom, if it's virtual, it's not as difficult, it's not as noticeable or interruptive, I guess, if as passing notes, because what I have the survivor do is have some type of chat open on the computer that's not in the Zoom, obviously, sometimes the app, or just directly on their phone. And I have them just check their phone, have that open throughout, so that we can communicate that way easily throughout the hearing.
Oh, sorry, I wasn't sure if we were frozen.
I think I got everything.
Thank you.
So the survivor is, again, with the respondent answering questions, they're going to have an idea of what the respondent should say, no matter what that respondent has said during opening. And most importantly, if that respondent has already answered questions from the hearing panel or has given an opening and there's facts in there that are, absolutely wrong, which there will be, that at least are inconsistent with what the survivor says, the survivor is going to jump and say, you have to ask him about this. No, that's not true. Make him say that's not true. And oftentimes that's not necessary. Again, you can point that out in closing if you need, or oftentimes it's on a fact that really doesn't go to whether or not the violation occurred, and it just confuses issues. And so I was going to be frustrated with that, kind of demanding, but that's why ahead of time you really need to prepare the survivor to know this really isn't your opportunity to get all the answers you want out of this respondent. This is an opportunity to ask the questions to get to the result you want. Unless I have had cases where the result the survivor is looking for may not be sanctions specifically, or they may not be as focused on that, and they really are focused in the hearing on healing and just their opportunity to speak for themselves and say in front of the respondent the things they need to say, how they've been harmed, remind the respondent out loud what they did. And in those cases, I may ask more questions of the respondent that the survivor wants. So I think that's all I got on cross now.
Great, thank you. So we've talked a lot about what is important strategically to cover from an attorney perspective. And you touched on something really important in that discussion, Kandra, where oftentimes it is difficult to have to be in a quasi-judicial proceeding, which is the heavy legal terminology for a campus disciplinary conduct, or any sort of like pseudo courtroom that is not an actual courtroom, where you're going through processes, because there are going to be things that a respondent says that in every situation I've been in, and I didn't mention this in too much detail at the beginning of the hearing, but prior to the clinic opening, I did take representation on in many Title IX hearings. And when I did, inevitably, there are situations where the survivor hears a false fact or a statement that does not align with what happened, and that is deeply, deeply jarring and harmful for that survivor. And what we find when we're working through these processes and these quasi-judicial proceedings is that cross-examination is not the only place where this happens, and that the survivor is not the only person that feels this way. So there are many situations, and this happens so much in K-12, because when you're in a K-12 circumstance, the parents are much more involved. We have found over time that parents are also heavily involved in campus proceedings as well, campus processes. But, I mentioned earlier that April sort of handles so many things for our clinic and does so many important tasks that help survivors and help their families. And so, while the individual survivor client is the core of our clinic's work, what tips do you have, April, for working with caregivers and parents who not only might be feeling the same amount of emotional harm and sometimes physical harm from these situations where they're not hearing the responses from a respondent that they expect, or they're not getting the outcomes they expect, but also when their expectations and what they want does not match up with what the survivor is looking for?
Honestly, I would, the first thing that comes to mind is just patience, because it's a situation that no one requested and that everyone has to deal with. And when I say everyone, I don't mean just the survivor. It's the co-survivors, the parents, the siblings, friends, extended family, even educators, especially since we're talking about Title IX. The generally within the school system, and specifically for K-12, but also at the university level as well. But and specifically for K-12, the educators, they usually have either relationships or time with both survivor and respondent sometimes. So as everyone tries to navigate through the process, everyone has their own emotions, everyone has their own feelings, everyone has, what is the show, SVU? They have their understanding of how things should work, and the expectation that their legal services team will be doing the same things that they see on television, I guess. And the challenge is that individuals, especially parents, they have a lot of guilt, anger, frustration, and not really knowing where to put that, because they want to focus on the survivor in the moment. They want to be the support structure, and at the same time, they need a support structure. So it is important with legal services and advocates, we're a team, and how we work together in supporting the survivor and co-survivors in their holistic healing. And sometimes it's not just going to be the answer that they receive in court hearings or in school hearings, but just the services that are available, and directing not just the survivor but the co-survivors in utilizing those services, and not feeling guilty for needing them themselves. It's extremely difficult to get a parent to even focus on themselves. And I've said this before, even when we're on the airplane and we get our instructions about traveling, we're told to put our mask on first. So one of the things that I say generally when I speak with co-survivors is, you have to put your mask on first before you can assist anyone. And that sounds really, poetic, but in the throes of everything in the day-to-day, it is not something that easily translates. So back to what I said originally, it's a lot of patience and understanding, and just trying to guide everyone to use the services that are available, to feel comfortable using the services that are available, and just trying to give information that it may not look the way that you expect, because like Kandra said, we have to work within systems. And I get a lot of calls with the aha calls, the case crackers, the things that, we say, this will do it. I know this will do it. But like Kandra says, she has to work within a strategy. You don't want to give the respondent or his advisor or their advisor ammunition to throw back and to change the outcome of the case by just putting out facts that are not necessary. So right back to what I said before, it's patience. I think the understanding that everyone is navigating through a process that no one intended to, and no one understands exactly what is going to happen or what to expect next. And, it's patience.
Thank you, April. And I just have a couple of follow-up questions for you. You were speaking a lot about the patience and the compassion, and I really loved, I can't watch SVU. I can't watch Law and Order period anymore. I think a lot of folks on this webinar probably also can't. Maybe a good, mid-90s Jerry Orbach episode I might be able to handle, but anything else after that, probably not. So, when we talk about Law and Order and we talk about expectations that can come up and can arise, one of those expectations that probably doesn't come from Law and Order, but seems to be present nonetheless, is that we are able to provide information to parents, specifically parents. There are a lot of secondary survivors, but parents present unique challenges in this type of context because we have confidentiality rules, and parents, and many of us are parents, and April is the perfect person to be communicating with parents because she has a bit more experience being a parent than I do. My child's only 2. And so I am the least experienced parent on the legal team. But Kandra and April both have children that are a bit older than mine. So, April, can you tell us about the direct notices we give to third parties and parents when we start representation about, what we will and can't do, even if they are in favor of something, and how that, how we respond or represent the survivor, but not necessarily the parent?
It's so funny, Camille, I get convicted every time I have to answer this question because I used to be that parent. I remember I used to be that parent. I did not care. I want this information. I don't even know what to call it. It was pretty much just the shock of when the lady said, well, ma'am, she's 18. I cannot give that information to you. And I thought, well, you just took my check. What do you mean? But that's a big change for a parent, and being on the outside of that with minor survivors, we have certain things that we can talk to the parents about. We have certain things that we have to exclude them, certain conversations that they have to be excluded from. Having the understanding that the survivor is the client and the parent is not so much, that's a challenge. I find specifically with parents, well, I want to talk to our attorney. Well, and then there are certain things that, like I said, with minor survivors that parents have to be present for, but ultimately understanding and having that separation, especially with this event that has taken place and this thing that has happened to their child. They want to be in the know. Parents want to be in the know about everything. And I guess did you want to say something, Kandra? I saw your face.
I don't want to take up a lot of space here. So we were talking about those, like April was saying, about the notices we give the parents at the outset. And one of the things for me, as the attorney, because I only have so much time to work the case and I have to work it within the written procedures, is I have to be really direct with the parents from the beginning. And so I have to, at the outset, say, you aren't the client, and here are the things I can talk to you about. Here are the things I can't talk to you about. Here are the decisions that have to be made by your child and not you. And here are the things that we are allowed or can do, and here are the things I can't change, right? I can't change the school policy. I can't make an administrator be nice on the phone to a parent. And that's, like April said, jarring, but it's really important. And then as the case goes on and they continue to ask for things perhaps, or, you know, have fears and frustrations, it's hard. But we have to just kind of repeat those direct, you know, as we said, can't do these things. Most times, whether it be K-12 or campus, but particularly in K-12, what the survivor's goal is not what the parent's goal is. Often, so the parent, like April said, is coming from that protective piece and wanting to, you know, seek punitive measures, or, you know, and the survivor is a younger person, and particularly in the K-12 context, where there's even more contact with parents or involvement with parents. The survivor is coming from a place of dealing with what just happened to them when the center of their world is their social world and their school world. And so their goal may not be to address it right away. Their goal may not be to go through the Title IX process whatsoever. And they may be following what their parents are suggesting because that's the only thing they know. And so often when I finally sit down with that and build that rapport with a survivor, even young ones, they will say to me, like, I don't even want to do this, or, like, you know, whatever, however they explain it. And then that can be really hard to go back to the parent and say, we're not continuing this right now. Really awkward for the survivor. And so you have to prep the survivor and say, like, I know this is awkward. I know what your mom wants. And I, you know, your mom cares about you. You're lucky to have their support, but I need to know what you want. And in campus cases, just from an attorney standpoint, one thing that's really important to do is there's very often times where the survivor has not told and does not want to talk to their parents about what's happened. So their parents may not even know there's a Title IX proceeding going on, or that they've been subject to sexual violence, or they may know that they've been subject to sexual violence, but they don't know all the details, and they don't want their parents to know all the details. In order to share information with a third party, a post-secondary, well, any school needs a release of information giving them permission under the law called FERPA. And oftentimes when a student begins a post-secondary institution, you know, there's a bunch of paperwork, and they will just go ahead and sign a release giving their parents access to their school records and their financial aid and whatever, without thinking. When a Title IX case starts, particularly if that student doesn't want that information to be given to their parent, if that parent, you know, calls the Office of Institutional Equity and starts asking questions about the case, then you need to get that FERPA release change. You need, in writing, you need the survivor to sign saying, I'm changing this, because otherwise the school may share information with the parents that the survivor is uncomfortable with. Also, you need to get a FERPA release for yourself right away.
Thank you so much. And I do want to make a shameless plug right now, because we are talking about education law-based acronyms, which are some of my least favorite things. So I actually used to be a teacher, and I always think it's really fascinating when I'm evaluating Title IX cases or policies, and I think to myself, we never talked about any of this when I was a public school teacher, and that wasn't that long ago. It was maybe 10 years ago. I should know when I was a teacher. It was 10 years ago to 14 years ago. I just forget what year it is because we just came out of the pandemic. But we are publishing at the end of the summer a civil legal manual, and there's an extensive chapter on Title IX that will have discussion points about the various education laws that intersect with Title IX. So we'll be providing that out to all of our member programs. And if you are a member of OAESV, please reach out for your copy. So I just wanted to flag that. But I wanted to shift gears just a little bit. We have about a half an hour left, and we have a couple of really important topics to go over. And One of those is something that I know. So Becca and I have been working together on cases for quite a while, and I am going to steer towards Becca for the beginning of this question, mostly because you have worked in a Title IX coordinator capacity at an institution, or deputy coordinator. I want to make sure I get your title right because I know that those are two very different things. But this is something that we've struggled with in so many ways, in so many cases. And I'm also looking for your input as someone who has been in the actual institutional setting. But this system, when you think about it, going all the way back to the 1970s when this was initially codified, Title IX is viewed as the women get to play sports to law. That is how it was conceptualized from the beginning, and it's been conceptualized that way thus for over 40 years. So how do we support survivors who are non-binary in a system which is so historically entrenched in a gender conforming and heteronormative verbiage, and is so fiercely tied to that by so many people? How can we broaden how we're supporting people, and how do we support folks in very specific cases when that is not does not apply to them?
Great. So I think to start with that, in terms of supporting survivors who either are like non-binary or identify or express themselves in different ways, is to start at home, right? To start with ourselves, right? So asking, do they have a preferred name? What preferred pronouns, right? So typically when I will introduce myself, I will offer my preferred pronouns there. If they, the survivor, provide them back to me, then I will continue to use those until I'm told differently. In this type of setting, I have seen it across the board, that folks will get misgendered by their schools, that they will not want to come forward because of sexual orientation, because maybe of the identity of the perpetrator. So even though we are in 2021, there's still, as we know, a lot of discrimination, and a lot of the schools and the laws haven't caught up to being equal yet. So I think we're still working on it, but making sure to ask those questions, right? Particularly when you're working with a survivor. And I would say both as an advocate, but also as an attorney, or April as a paralegal, right? That we all have the opportunity to do that, right? What is their preferred name? What is their preferred pronouns? What I would say about that, though, is to be very conscientious of when you're asking that. So you should not be going into your first meeting and you've got like surrounded by their family and they're like, what is your preferred name and pronouns? Because they may not want their family to know about it, right? So when we're talking about that FERPA release, they may have signed off saying, yeah, my family can get access to everything, because when you're 18, you might just sign whatever papers are in front of you because you just want to go to school at that point, right? And if your parents are telling you to sign something, sometimes you read it, sometimes you don't, you just call it a day, right? So they may not be prepared, ready, willing, able, right? They may not want their parents or caregivers or their siblings to know any of that kind of stuff, right? So they might not want that. So as best you can to kind of do that in that one-on-one setting, to make sure to be able to address it there, but also to address how they would like to be addressed in a Title IX hearing, right? So they may have a preferred name that they want to use, but they may not be going by that at their school, right? So they might be using something else entirely by their school, and their school may not use those preferred names as well. Sub-schools are adjusting to that. I've seen that there are some institutions that are allowing that change, whether in formal or informal settings. Others are just not there yet, right? They have not breached that yet. So to really touch base with the survivor about what their comfort level is, what they're looking for, and where are they comfortable in terms of the meetings with you, but also in those settings that are more formal, right? Those Title IX hearings. Would they prefer to use they pronouns, but in Title IX hearing, they're like, no, I want to use she pronouns or he pronouns, right? Because in that setting, that is not how I want to be identified. I also want to call out, as of last week, which is very exciting, June 16th, if my memory serves. So I think we're less than a week out. The U.S. Department of Education put out a statement confirming that Title IX protects students from discrimination based on sexual orientation and gender identity. So that is something to also keep in mind as well, that if you're seeing that the school is discriminating based on the sexual orientation or on gender identity, that is also a Title IX issue. So sometimes what we will also run into is that the student is like, I don't want to move forward. I don't want to do this, that, right? They don't want to report because of this, because they're afraid of being discriminated. Or in our world, right, at OAESV, sometimes people will come at us and they'll ask the question like, well, they weren't sexually assaulted, so Title IX doesn't apply, right? No, they don't. It doesn't need to reach the level of sexual violence, right, of a rape, in order for Title IX to apply, right? So as of last week, the Department of Education did confirm that sexual orientation and gender identity are both included in that. So if a student is being discriminated based upon one of those, that is also a Title IX issue. So I did want to also make sure and throw that out there as well, because that is also fresh, just off the presses last week. So if you have not read that, I would encourage you to reach out. It's pretty short, so not a long read, not long homework for y'all, if you're curious about that.
Thank you, Becca. And I had just sent Becca a direct message that I was about to put her on the spot, which I feel like I have to do at least once in every presentation we give together. But she brought it up on her own, so I did not have to do that. So thank you so much, Becca. So I am going to now open it up to all three of you to talk about something that many of the folks on this webinar, I think will, sorry, I got a direct question from a member of the audience, so I got a bit distracted, but let me steer back. So one of the functions of Title IX is to provide accommodations for survivors and make sure that they have safety planning and have access to their educational resources. So it's not purely a punitive system. And so what that means is that sometimes what we call more informal resolution processes are recommended. So according to the Title IX rules, mediation might be allowed in some cases, and survivors may be interested in restorative justice. So how do we approach both mediation and restorative justice when sexual violence is rooted in oppression and power-based violence, with noting the caveats that under the traditional principles of mediation, there is sort of a requirement that both parties admit some degree of fault, and other more traditional aspects of mediation.
I can answer briefly. I don't recommend that survivors partake in informal resolutions or mediation unless their ultimate goal is that restorative justice or is a discussion with the respondent, you know, that they're not interested in punitive measures or sanctions, and they're very clear about that from the beginning. And that is because informal resolution processes, like you mentioned, Camille, can be really unbalanced and can, particularly for survivors who are already feeling discriminated against or unheard. Up until the new rules, many schools just didn't permit mediation in any type of sexual violence case. Anyway, in mediation, so the other thing is that every school is going to have a different process in place for mediation or negotiation or whatever some of them allude to a restorative justice session or sessions toward restorative justice. There's no requirements about what that has to entail. And that is really frustrating as an attorney advisor when you're trying to help a survivor make the decision about whether or not they are interested in an informal resolution. But that also creates an opportunity for us to help shape what it looks like. And so what you just mentioned, for example, is historically or more traditionally, I guess, in other legal settings, there is often a requirement or understanding that both sides will admit responsibility for something and will give up something. In there's like the kind of a trade. It may not be even, but there's some sort of balance there. My advice is before engaging in an informal resolution, because again, it's always an option for both parties. They can't be forced to do it. They can't be pressured to do it because the other side wants to, or the school thinks it's a good idea. It's always up to the survivor whether they want to participate in that process. And if they, so there will be like a conversation with the school ahead of time. The school will ask if the survivor is interested and give them time to consider it. And what I do is I will make demands or hard suggestions about what it should look like to the school. And I may say, the survivor is willing to engage in an informal resolution under these parameters, and that may include the survivor will not be accepting responsibility for anything related to this. The survivor, these topics are off limits or whatever it may be. That may mean that it doesn't happen because the other party or the school may say that's not going to happen. But that you've at least asked for that, and then the survivor can decide whether or not they want to go through with it when those boundaries aren't guaranteed. The other party also has to agree to informal resolution, and so typically what will happen is sometime during like the investigative process, the school might reach out and say, the other side is interested in informal resolution, are you too? Or you may say, can you ask the other side if they're interested in that? If both parties say they will do it, then there's going to be some sort of informal hearing. And it's hard to say what that's going to look like because again, the schools kind of set it up. And frankly, I don't think a lot of schools have done it yet. So I don't know that they even know exactly what it's going to look like, and it may be different case to case. But one thing to keep in mind and to tell survivors throughout is that they also aren't they're not locked into informal resolution once they agree to do it. And so they can begin exploring those processes and trying to reach a restorative justice solution. But if it feels like that's not going to be satisfactory to them, or it's becoming combative and more harmful to them than helpful, then at any time before there's some sort of informal agreement signed, they can pull out and say, I don't wish to do this. And what would happen then is the regular process would just take back over the formal process, that being the regular grievance process, investigation and hearing.
Thank you so much. And I do just want to highlight, do I sound like a vampire to everyone else, or is that just coming in on my speaker? Okay, perfect. You brought something up that brings me, I just want to highlight one thing. So in our time doing Title IX cases, we have found very wide disparities in what I would call sufficient comprehension of Title IX processes at various institutions. So some campuses are to the letter, know exactly what those regulations say and how that applies to their students and their programs. Others, for various reasons, maybe have a different viewpoint or a different understanding of how the process or the rules work, especially when you get to K-12 institutions. Now, I think by the time we're talking about mediation, we are largely more so talking about adults, and we are therefore talking about the higher education processes. But what I will say is, there was something in the 2018 proposed regulations that I just want to highlight for all of you, because even though Kandra is absolutely 100% accurate in saying that there is in the rules now, it says that if someone does start exploring informal resolution and that does not work out, they can then reconvene the formal resolution process. But in those 2018 rules, that was different. So it was sort of an option that could be provided that would discontinue that formal process. So what you may hear from a new or confused, which is justifiable because Title IX has changed very quickly several times in the past. In the time I've been here, it's changed 3 times. So you may hear someone say, well, we started informal resolution, you waived your opportunity. And it's important that we all inform the survivors that that is not accurate, that you can go back to that. And Becca, I saw a look on your face. Am I speaking not factual information? Please correct me if I am.
No, you're good. That is something I wanted to, I also sent you a message earlier. I wanted to make sure and address is just to be very clear about what those rules are at your individual institutions, whether K through 12 or, well, mediation doesn't have anything to do with K through 12 at the higher education, because there are going to be some schools that are going to be looking to apply it as if you can't go back to formal. So once mediation is completed, typically that means you can't go back to the formal complaint. So something that we ran into and that we've had questions about is their interest in mediation because they just want to be safe. They want the person to not be around, but they don't want to affect their life forever. So something that we'll see is they'll want to do the mediation, but then the mediation doesn't work. So then they want to go back to the complaint, and that probably isn't going to be an option. So just being very clear about what those rules and regulations are at that institution, so that those avenues aren't cut off, which as an advocate, right, I'm just like options, right? So I'm just being very clear, knowing that institution's policies about what mediation may look like if it is an option that a survivor chooses to take.
I do think, Becca, that they have to allow the formal process now to resume if mediation doesn't continue because a party decides not to do it. And the only reminder I would give is that it may be the other party that decides not to continue with informal resolution and decides instead to do formal resolution, and that can be really disappointing to a survivor who was hopeful they wouldn't have to go through that formal process for whatever reason. So, that's a warning to keep in their mind. If it seems like it's going that way and an informal resolution is not going to work out, I would recommend getting out of it as soon as possible so as not to give any, additional information perhaps to the other party that won't be strategic in a formal process. Yeah, that's it. Oh, and finally, it's in the rules, but an employee, so if the employee is the respondent or the complainant, informal resolution is not an option.
And I just want to make sure we covered the message that you had sent me, Kandra, that they don't have to go through the formal process after they complete informal. So if a survivor elects to accept the option of informal, if they decide that's not working and they want to stop, they do not automatically have to go back and do the formal process. If they just decide I am done with this, that is okay. And I'll have Kandra elaborate on that just a bit.
Yeah, and also, that is because at any time they can decide to no longer go through with the grievance process. The rules say that a school can continue it under their discretion if there's, a threat to safety of the community or whatever it may be. I've never seen that happen because they also take into consideration the parties or the complainant's wishes. So a survivor can, become the complainant and at any time decide that they're no longer interested in the formal process for whatever reason. The respondent cannot just make the formal process go away by just saying, I'm no longer interested in the formal process, but they do not have to participate. So they may not interview with investigators whatsoever, and they may just show up at the hearing, which again is really frustrating because you don't have any previous statements by them to work off of, but they have that right. Or they may not come to the hearing or may come to the hearing and say they're not answering questions. They have all those rights. Obviously, the only evidence then that a hearing officer can use to determine whether or not a violation occurred is what information they do have. And if they don't have information from the respondent, they can't consider it. But just to remind the survivor that either witnesses or the respondent can't be forced to participate, because that can be really frustrating too if they were hoping for some sort of answer from the respondent. And that does happen more and more. I think perhaps attorneys are telling them they don't have to participate, and they just don't, especially if they think they're going to be sanctioned.
Thank you. So we have 15 minutes, and I want to squeeze into those 15 minutes a very, very important topic that really, for us at OAESV, other than cross-examination, may have been the most significantly disturbing shift to the Title IX rules. And Becca does not know what I'm about to say, so I am putting you on the spot.
Just one.
Sorry. You're right. I say that every time. I'm like, this is the worst part. So also, I wish my 2-year-old was here with me, because she has a lot to say about this topic, because she's heard more about it in her brief life than almost any other topic. So when from Richard Nixon through the beginning of the Trump administration, which is a very long time, that's longer than my entire life, we had very consistent rules that said that the sexual violence or sexual harassment did not have to occur on campus for it to be actionable. It merely had to affect the educational experience, which becomes more and more important the further we get into social media communications, because something can happen literally anywhere and can have a huge impact on sexual violence survivors. So many of you have heard of the Clery Act, and I'm not going to get too far in the weeds about this, but we used to have essentially big geographic questions about the Clery Act and what had to be reported and what didn't have to be reported. But now we find ourselves answering questions about, is this actionable by the school based on Title IX? So I'm going to give you a really brief summary before I open it up for our last bit of group discussion. So there's, the word jurisdiction, which you may have heard on SVU or regular Law and Order or Law and Order Criminal Intent or Legally Blonde or any other legal drama that might have come across your television screen. And jurisdiction means that you have the capacity to investigate or handle a matter or make decisions on a matter in a certain geographic area. And so under prior Title IX rules, campuses had jurisdiction over any act of sexual harassment or sexual violence that impacted the student's educational experience, regardless of the geographic origin of that action. Under the new rule, they no longer have jurisdiction over the vast majority of experiences, and I'm going to have Kandra, Becca, and April go into a bit more detail because I'm a bit rusty on this. But it has to be, in my understanding, is university-owned property, which essentially is classrooms, libraries, student, like freshman residence halls, dormitories, things of that nature, and things that happen off-campus owned property. They don't have the jurisdiction under Title IX to investigate or handle those matters, which is a huge change and is hugely problematic. Now, my understanding is that they can use other jurisdiction, other rules, like their own student conduct code, to investigate those, but they cannot pursue them as a Title IX action, which means that defense attorneys could argue you are engaging in sexual harassment of respondents because you're choosing to investigate something that Title IX doesn't even give you discretion to do. You're creating other ways to do it. So I will stop. I know that impacts parents and co-survivors in a lot of ways because they have often justifiably, I am working very remotely and distantly from this at this point, but I still get very upset when I think about how many of my clients' cases would not have even been able to be processed if the rules in place right now had been in place when their sexual violence occurred. So please share kind of any and all thoughts you have, knowing that we have 11 minutes left before we wrap up, about how this affects what we're doing, how likely it is that this will change, and how we can help support survivors and their families in understanding that this geographic restriction exists.
I don't want to take up too much space because I'm, again, chatting a lot, attorney. So I have been pleasantly surprised that probably majority of the schools that I've worked with are handling things that aren't specifically, or at least possible, there's a possibility it doesn't constitute on campus or, those really strict Title IX jurisdiction requirements. They are processing them under a code of conduct process, and that code of conduct process mirrors the, in most ways, pretty much every way, I think, the grievance process in a Title IX matter. I think the way the schools are going to get around that is that they're applying that process to all at least serious infractions or disciplinary measures under a code of conduct policy. So what that means is other types of code of conduct violations that may not have been handled with such a formal grievance process may now be. That may be frustrating for the school to have to do that. I have seen schools where they have different processes for, so if the sexual violence type things are handled under the code of conduct, what they'll do is say, here are the serious infractions that will be handled by this formal process. Here are the code of conduct violations that will be handled by this different process, so that, a allegation of academic dishonesty or something doesn't have to go through that formal process. I think, so what I would say as an attorney, if the school doesn't have that in place, right? And so if their policy is that specific Title IX jurisdiction requirements, and it doesn't look like there's a space within the code of conduct to address it, I would advocate for the school to make that change. It may not help that specific survivor, but showing the schools how other schools are doing it may make them willing to do it. I do see it more and more, so I think they're being trained on it somehow to do that. I will say that what I've also seen is that the schools are being pretty broad as much as they can with the jurisdiction requirements. And I think that's just because they don't get it. They don't understand it. Nobody understands it. And previously they were more broad at many institutions. And so they kind of lean toward what they were already doing. Will that become a problem when there's lawsuits over it? Probably and maybe. The caveat to that being that the new administration seems to be more interested in providing a fair and perhaps survivor trauma aware process of Title IX, and they are looking at the 2020 regulations and considering changes. No changes have been made. We don't know that there will be, and we don't know what they will be, but they're considering changes. And so if there are going to be changes, I would not be surprised if that jurisdictional piece is broadened or at least made more specific so that schools know specifically what is and isn't under the Title IX realm. What I will say too is that students may get caught up in saying, well, that happened off campus, that assault happened off campus. I always look for things that link to something that happened on campus. So link that piece of sexual violence, however you may, or that, pattern of dating violence to something that happened on campus. Focus on that piece and at first, to get it within the policy. And then talk about the detail, so if you can link it to that, and I've gotten it through with, with even text messages during class being sent about the sexual violence. You know, a few pieces of dating violence happened while they were walking around campus and whatnot. And so that, because that pattern did happen there and elsewhere, the whole pattern was considered. Whether that's right or wrong, it's working for now, at least some places. So I would make that recommendation. I am hopeful that the jurisdiction at least is more solidified, if not changed much, because it really is vague in what the school can handle, and really just senseless. Students don't all live on campus, but if they live across the street, they should also get the same protections.
Thank you, Kandra. April or Becca, do you have anything?
I'm going to jump in real fast. So April, please stop me if you also want to jump in. The only thing I would add to that is I also have kind of been seeing that trend that Kandra was talking about is the caveat of, like, in the US is also something that has been a little bit stricter in these regulations. But I've also seen that there are other policies. So it may not be Title IX, but there might be other policies that are going to encompass that, right? So particularly I see questions in regards to international students or study abroad, that if someone is in study abroad, or if they're an international student that has gone home, or whatever that might look like, that it may not be classified as a Title IX, but there's probably another policy that might be in place that they could look at, right? Especially if it's affecting their life back on campus. So like Kandra was talking about, if we can link it back. So something that looking at in terms of working with a survivor is that explaining that it may not be called Title IX, but there's still a way that the school can address it, right? So it may not look or sound quite like they might expect it to be, but it might be a difference between, right, like 2 different felonies or something in criminal law, right? That it can be addressed under a different policy. So just kind of being aware of that as well in terms of the, particularly for international and study abroad programs, that we are also seeing that as well, to kind of just be aware that US requirement has been a little bit stricter as well.
Which isn't new.
No,
It was always the case that, you know, a physical assault could be handled under the code of conduct, even if it didn't constitute sexual violence. So the schools are familiar with how to do that. And typically survivors don't care that it's not under Title IX. They just want it addressed. I mean, survivors often come in not even knowing that Title IX is what they'll be doing. And so that shouldn't be an issue. Just look for those policies, like Becca said.
Okay. April, did you have any thing you wanted to add before the end?
I did not. I was on the same lines with Kandra, with linking the incident to some other incident with, through text messages or any communications, especially digital communications that mention maybe the event that was off campus. So I was on the same lines. Thank you.
And I'm sorry, April. I just still, my basic thing I've been telling in all these trainings, or all the trainings we do on the new Title IX, is this is an opportunity to be creative. The rules don't answer a lot of questions and leave a lot of holes. And if anybody's going to open that, it should be advocates and supporters of survivors. And so be creative in what you ask from the school and how you advocate, because the worst thing they can say is, no, that's not how we read the new rules. But I also see that they are looking for answers too. And so you may be able to convince them.
Well, we thank you so much for your time today, and I'm going to hand off the closing, but we appreciate you all. We talk about Title IX more than we talk about anything else, probably, at least I do, and we have a lot of trainings coming up in the coming year. So whether the rules change under the Biden administration, which we really think they will, or they stay the same, which we don't think is going to happen, we will be training at least for 2 days in September, which I will also shamefully plug. And with that, take it away, Bree.
You are muted, Brianna.
Wow, wouldn't be a conference if I did not end on mute. Well, thank you for that. We appreciate you. The CEU and the CLE code for this session is campus. Next on your agenda is a 15-minute break, followed by the workshop session starting at 3:15. Please refer to the oaesv.org/2021 conference program for joining links.
Oh, I haven't brought Mark Harmon up yet. I have to bring up Mark Harmon. Becca brings up Law and Order, and I bring up whatever show that is, NCIS. There, it's done now.
I'm going to put my email in the chat if anybody does have questions about working with survivors or need links to getting them legal representation, like we really think is best. Reach out anytime.